Good afternoon, everyone. Welcome. Thanks for being here. I'm delighted to welcome you all to the 2025 Belinda Sutton Distinguished Lecture. I'm going to say just a few words about Harvard Law School's history and this lecture series, and then we'll get on with the real business. So, as many of you know, thanks in part to painstaking research of some of our amazing colleagues, including Professor Janet Halley, Annette Gordon-Reed, Martha Minow, and Dan Kokolet, as well as Dean Tomiko Brown-Nagin, we have been engaging for some time now with the challenging and painful aspects of this school's founding. As you know, probably, if you're here, a 1781 bequest to Harvard College from Isaac Royall Jr., who earned his wealth from the labor of enslaved people, including this event's namesake, Belinda Sutton, funded a professorship that helped establish the law school in 1817. Thus, our school was founded in part with wealth generated through the abomination of human slavery. Belinda Sutton, whom we honor here today, was born in West Africa in the early 1700s. She was captured by a party of slave traders before her 12th birthday and was cruelly torn from her family, friends, and home, endured the horrific Middle Passage, only to be compelled to spend the next 50 years of her life laboring in, quote, ignoble servitude for the benefit of Isaac Royall, unquote, whose plantation home, by the way, is located in Medford, Massachusetts, about 3 miles northeast of here. After Royall fled to Canada and then England amid the outbreak of the American Revolution, Belinda Sutton lodged a historic series of legal petitions with the Massachusetts General Court to claim her rightful pension from his estate. Despite initially convincing the legislature to grant an annual pension of £15 and 12 shillings, only one payment was ever made. More than 2 centuries later, Belinda Sutton's eloquent appeals for a minimum of recompense after a lifetime of servitude is a ringing testament to her life, to the way she overcame the oppression and indignity that was visited upon her, and to the aspirations, endurance, and fortitude of the human spirit she and so many other enslaved persons demonstrated in the face of unspeakable adversity. It was to honor Belinda Sutton and other enslaved persons whose labor contributed to the law school's creation, to deepen our understanding of the legacy of slavery, and to further the unfinished work of advancing equal justice under law, that then Dean John Manning in 2022 established the annual lecture and conference series that brings us here today. The series kicked off in November 22, and I was delighted last April to welcome scholars from across Harvard and the nation, including today's speaker, to the inaugural Belinda Sutton Symposium, which was titled, quote, Charting the Aftermath of Equality, Brown, SSFA, and the Continuing Struggle for Racial Justice, that event was dedicated to the memory and legacy of Professor Charles J. Ogletree, Jr. Of this faculty, who passed away in 2023. So that's some background and context for what we're going to be hearing about today. But most importantly, I need to introduce 2 people. First, I will introduce my wonderful colleague, Professor Guy Uriel Charles, the Charles Ogletree Jr. Professor of Law and the Faculty Director of the Charles Hamilton Houston Institute for Race and Justice here at HLS. He has commanded that I not give him an elaborate introduction, so I will just say, Professor Charles, if you don't know him already, you ought to. He's an extraordinary teacher, scholar, colleague, and human being, and I am every day grateful that we get to be colleagues. He, in turn, will be introducing our speaker, our Belinda Sutton Distinguished Lecturer, our own 1994 graduate, Professor Devon Carbado. We are grateful to you, Professor Carbado, for helping us to address the legacy of slavery and the important role history plays in enabling us to build a more just future. Lastly, I want to express my gratitude to the staff of the Charles Hamilton Houston Institute for working with Professor Charles to organize today's gathering and all the events in this series. With that, please join me in welcoming Professor Charles.
Thank you so very much, Dean Goldberg. It is my distinctive pleasure this afternoon to introduce my brilliant and elegant friend. And if you don't know Devon, you will first notice his elegance and then hear his elegance. So in his honor, I wore my scarf today to this podium, which will not do the elegance justice. Devon is a graduate of earned his undergraduate at UCLA, and as Dean Goldberg said, is a graduate of the Harvard Law School. He writes in the areas of constitutional law, criminal procedure, race and law. I've relied, especially in the context of race and law, on his wonderful and amazing scholarship. His work has appeared in all of the places that one expects the work of great scholars to appear, in all of the top law journals and all the top law reviews. He has published a number of books and edited volumes, including Black Lives, Police Power, and the Fourth Amendment, Acting White, Rethinking Race in Post-Racial America, The Long Walk to Freedom, Runaway Slave Narratives, Race and Race Law Stories. He is the winner of many literary prizes. He has also won 2 prizes from the AALS Minority Section, the Derek A. Bell Award, as well as the Clyde Ferguson Award. The Bell Award is awarded to an extraordinary person who's made an extraordinary contribution to legal education. The Clyde Ferguson Award to an outstanding law teacher who has achieved excellence in the areas of public service, teaching, and scholarship. He is currently at the NYU Law faculty, but prior to that, he was a professor at UCLA, where he was the Honorable Harry Pregerson Professor of Law. At UCLA, 2 graduating classes elected him Professor of the Year. He received both the law school's Rudder Award for Excellence in Teaching and university-wide Distinguished Teaching Award. He has held several administrative posts, including the roles of Vice Dean, Associate Provost, Associate Vice Chancellor, and he has held the Newcomb Chair at the American Bar Foundation, the Culverhouse Chair at Stetson Law School, and he was the Scheiks Fellow in Civil Liberties and Visiting Professor of Law here at Harvard Law School. There are many things that one can say about a superlative academic, though you are not here to hear from me say those things. But let me just simply say that we are all grateful to Devon Carbado for his amazing intellectual and deep work. And I am personally grateful to him for all the work that he has done in helping us to understand the possibilities of equality, the limits of law, and wrestling with our history. It is my distinctive pleasure this afternoon to introduce Devon Carbado, the Elihu Root Professor of Law at NYU, presenting for us Law and the Afterlife of Slavery. Devon?
Thank you for that incredibly generous and kind introduction. In fact, precisely because it was so kind and generous, I should have to ask you to do what my kids, when they were young, would implore me to do, which is to say, just pretend, Daddy, just pretend that it's real. So pretend everything that Guy Charles has said is real as a predicate to my carrying on. I really am delighted to be here. It's always a treat to come back to the law school, but I'm particularly honored and privileged to have the opportunity to deliver the Belinda Sutton Distinguished Lecture. It seems to me that in a context in which there is contestation about the production and dissemination of knowledge about race, reckoning with the hard history of slavery might be a particularly important intellectual endeavor. Doing so invites us not just to think about the historical moment of slavery, but also its afterlives, a term about which I will say more presently. As a prelude to doing so, I should take care to note that my thinking about hard history actually arose in a very different context, studying the historiography of the Nazi regime with Professor Saul Friedlander at UCLA and the violence of that regime and its genocide on the Jewish people. Some of you are undoubtedly students of that period and might even be familiar with some of the historical debates, sometimes referred to as the historians' controversy, about, for example, whether the Nazi past is quote-unquote masterable, about whether we can and should think of that past as quote-unquote normal history, about what it means to incorporate that past into the present, about collective memory and commemorative practice, and about whether that past refuses but should or should not be made to go away. Of course, scholars in the domain of chattel slavery have engaged in similar kinds of debates, and indeed the inaugural lecture by Martha Jones is a wonderful example of scholarship in that particular tradition. But precisely because I am not an historian, though I sometimes play one in my scholarship, much to the shock and horror of historians, but because I'm not an historian, I will not attempt to map historiographical debates about slavery. What I thought I might do instead, consistent with one of the purposes for which this lecture was established, to make sense of, come to terms with, name and remediate the legacies of slavery, is to think aloud with you about what I'm calling law and the aftermath of law and the afterlife of slavery. As some of you might know, the term the afterlife of slavery emerges in the brilliant work of Saidiya Hartman. In explaining how she came to that particular locution and the intellectual sensibility on which it rests, she writes, "I could feel the force and disfigurement of slavery in the present. The life of the captive and the commodity certainly wasn't my past, but rather my threshold, the threshold of my entry into the world. Its grasp and claim couldn't be cordoned off as what happened then. For me, the relationship between slavery and the present was open, unfinished." Broadly articulated, my aim today is to capture some of the dimensions of that unfinished business, to capture, in other words, some of the ways in which the relationship between slavery and the present is open. A critical starting point for that engagement is to conceive of slavery not simply as a particular event that happened in the United States at a particular historical juncture back then, but rather as a structural phenomenon that configured society, that configured institutions, and that configured people on racially hierarchical terms, the effects of which we're still grappling with in the here and now. Under this formulation, slavery wasn't just an event that happened in the past. It was a form of social engineering that was always already making a racially subordinated future, which is to say, the violence of slavery wasn't just in its chattelism, but also the fact that slavery wired racial inequality and Black subalternity into the social construction of race, into the very intelligibility of race, and into the racial ordering of society. Now, to develop that claim, I've organized my presentation into 3 acts. I'll begin in Act 1 with a claim that race is a social construction. You have all heard some version of that claim. Indeed, I'm tempted to have you all stand up, hold hands, and say it together with me. Race is a social construction. Presumably nothing magical would happen. I would still be yapping on up here and you would still be sitting there. So what finally is at stake with respect to that claim? And how might it help us think about the relationship between slavery and its afterlife? That is precisely the matter to which I will turn in Act 1. Act 2, I will invoke another concept with which you are presumably familiar, which is to say structural racism. Here too, I'm meaning to draw a nexus between the quote-unquote then of slavery and the quote-unquote now of the present to reveal why it might be important for us to think about an afterlife. Finally, Act 3 will turn attention to law. Presumably, for once, I don't have to apologize for doing that. We're in a law school, for crying out loud, and indeed a law school that sometimes fancies itself as the law school, so I don't think I need to apologize for talking doctrine. Scene 1 of Act 3 will focus on the 14th Amendment, and more particularly equal protection doctrine, and Scene 2 will focus on the 4th Amendment, and more specifically, the seizure doctrine. My aim here is to reveal the degree to which these doctrinal domains are not ones in which the Supreme Court takes seriously structural dimensions of race, and in many respects, what I will be calling it the afterlife of slavery. All right, so let's start at the very beginning, because it's a very good place to start, with the social construction of race. What do we mean by the social construction of race? Well, we might begin by noting that there's a blank screen, which is to say, race isn't yet there. At some particular moment, race has to come into being as a basis for boundary work. boundary work between and among nation states, and boundary work between and among people within particular nation states. We could have a knockdown, drag-out fight about when this happened, how it happens, etc., but we won't do that. We'll simply stipulate that at some particular moment, race is intelligible to us, and we'll call this moment one. To say that there is this thing called race is not yet to determine the racial categories through which it will be governed. This is moment two, the delineation of particular racial categories. And even the most preliminary engagement of something like the census over time reveals that different racial categories have come in and out of being at different historical moments. Moment two, then, is the delineation of these racial categories. Moment three is the rule, or rather are the rules of racial mapping, or the specific criteria we might employ to stick people into racial boxes. If I were to say, hey, I'm a white guy, that claim is easily falsifiable precisely because of some of the rules of racial mapping. These are some of them. Presumably you're familiar with them. I'm in the process of looking across historical moments, across different doctrinal regimes, to see the work that courts have performed, drawing on these specific criteria to put people in particular racial categories. To give you one specific context as to how this has worked, historically in the context of slavery, I turn your attention to this particular case, Huggins versus Wright. It's decided in 1806. So the litigants in this case are all asserting a right to freedom. And whether they get to do so turns on whether they can trace their ancestry Butterwood Nan, A, and her particular identity as indigenous. So we have the grandmother, Anna, the mother, Phoebe, and the granddaughter, Jackie, who the court describes as, quote unquote, perfectly white. You'd be surprised the degree to which that phrase appears in these cases. So in thinking about racial identity, here's what the court has to say specifically about Blackness and how you know whether someone is or isn't, and indigeneity and how you know whether someone is or isn't. Nature has stamped upon the African and its descendants two characteristic marks besides the difference of complexion, which often remain visible long after color disappears: a flat nose and a woolly head of hair. The latter of these characteristics disappear last of all. Obviously not so with respect to me. So pointed is the distinction in hair between the natives of Africa and the Aborigines of America that a man might as easily mistake the glossy, jetty clothing of an American bear for the wool of a black sheep as the hair of an American Indian for that of an African. So there you have it, clear articulations as to what is black and what is indigenous. But there's more. The court also imagines three different litigants appearing before a judicial body, and the question is whether or not they get their freedom, and that turns on who they are. So in category one, and all of these terms are terms that are in the case itself. The person appears black, woolly, flat nose. These are the court's characteristics. So you now have to shout out the race. Just do it. After three, the race is... All right, look, you're so hesitant. Just say it. The race is black. And so the court says, if that's the case, then the burden of proof is on the freedom seeker. So we're seeing articulations of race bound up on a doctrinal burden-shifting regime, which is precisely why we talk not just about the social construction of race, but the legal construction of race. Category two, the person is now copper complexion, long, straight black hair, no information about the nose. Race? I'm not so sure. Yes, indigenous, the court says. And in this particular moment, the court tells us the burden of proof is therefore going to be on the enslaver. Final category, fair complexion, brown, not woolly hair, Roman nose. And just to give you a sense of what we might mean by Roman nose, there you have it. You probably wanted to know. Don't say I didn't provide important information in this context of this particular lecture. I think I just did. You get the idea. What I'm trying to reveal again is that law isn't just reflecting ideas about race. It's actually constructing race. And this is just one example of that particular dynamic, it seems to me. The fourth aspect of the social construction about race that we should think about is social meaning attributions. So now we're simply asking ourselves, what kind of social understandings historically have mapped onto different racial categories? These are just some of them. I don't mean to cover the entire terrain, but it has been the case that inferiority has been mapped onto blackness. Pretty hard to dispute that. It has been the case that superiority has been mapped onto whiteness. Pretty hard to dispute that. And it has been the case that disloyalty and notions of foreignness has mapped onto people of Asian descent. And again, I'm just trying to capture some of the ways in which this has happened. If people want to quarrel with me about these social meanings, then please feel free to do so. And now we need to think about the structuring of racial experience. The point here is that social meanings of race are not just abstract phenomena. They relate to the very material conditions of race on the ground. So to the extent that you're inferior, then slavery becomes a condition of possibility. If you're superior, freedom, and if you're disloyal, internment. There's a relationship, in other words, between social meaning attributions of race on the one hand and the racial experiences that a group might have. And the final dynamic that I need to point out here is the confirmation of the social meaning as a result of the particular racial experience. To put that more precisely, to the extent that you're enslaved, it must be because you're inferior. Why else would we enslave you? If you are free, it must be because you are superior. Why else would you be free against the backdrop of a slavery regime? And to the extent that you are interned, it must be because you're disloyal. We wouldn't intern you otherwise. So the fact of the racial experience then is another rearticulation of the social meaning. And this particular dynamic is just one way of capturing what I've just said in a more heuristic way. Now, I should be careful to note that I'm not suggesting that racial formation occurs in this nice, tidy one through, I mean, it doesn't. This is a pedagogical device to put into sharp relief. Some, not all of the dynamics are at play. And it seems to me that it's pretty hard to say that this particular configuration of race dies with the formal abolition of slavery. Formal abolition of slavery, of course it happened, but particular understandings of race lived on. And indeed, one way to think about that is to make a disciplinary turn to the field of social psychology and ask ourselves, to what extent have social psychologists been in the business of helping us think through social meanings of race and the extent to which they might be alive today? So one of my co-authors conducted this particular seminal study, and what they wanted to do is precisely to explore as an empirical matter whether they could demonstrate that there is some way in which collectively we're thinking about social meanings of race and Black people with respect to notions of criminality. Can we demonstrate empirically that this is so today? And they pursued this particular project by priming the participants with Black male faces, white male faces, or no faces at all. So you're sitting in front of a computer screen, and you do not know that you've been exposed to this particular image because the image is popping in and out too quickly for you to know that you've been so primed. And then the charge is, can you recognize particular objects? And there are two kinds of objects about which the researchers were concerned. A crime irrelevant object, like an iron, which is circled, and I always have to explain to my student that's an iron. It's useful, it's not a prehistoric tool. And then a crime-relevant object, like a handcuff or a gun. And you might say, well, Devon, I know an iron when an iron, I don't see the problem. The difficulty is that the objects appear before you at different levels of degradability. So if I were to show you this particular frame, this is frame 1, you may or may not be able to discern what it is at this frame. If I show you frame 25, perhaps you can begin to see what it is. And at this frame, frame 41, those of us who are sight privileged can say, yes, I see it, it's a gun. And the question becomes, to what extent does being exposed to a particular prime affect the frame at which you see these objects? That's the question that the researchers wanted us to think about. And so here are the results. All right, so I'll pull up the blue bars first. And you'll note that the bars for the crime irrelevant objects, I'm thinking about the iron, don't reveal a difference across the three priming conditions. By that I mean, whether you're primed with a white face, a black face, or no face at all, you tend to see the iron at the same frame. If I pull up the gray bars, the scene looks a little different. You see that whiteness inhibits your capacity to see the gun or the handcuff. It's not a gun, it's not a gun, it's not a gun. Okay, fine, it's a gun. And with respect to the black crime, it's a gun. So this is just a way of communicating a basic proposition with respect to the social construction of race, which is to say that there are still social meaning attributions that are alive as well. Significantly, this is a study that included police officers as well as undergraduate students, so the sense is that this could be relevant to everything from policing to how people are imagined in academic institutions. The broader point is that if we recall that part of the social meaning of race is its role in the construction of race, then again, it's hard to say that this particular dimension of the social construction of race doesn't have an afterlife. We can debate how salient that afterlife is, that's fair. We can debate what work it performs, structure in society, that's fair. But to say that there isn't an afterlife to this dynamic seems to me easily falsifiable. So let's move to Act 2. So now we need to think about structural racism and have an understanding as to what precisely it might mean. And part of the difficulty here is that engaging in a conversation about structural racism is something of a conversation stop. I mean, if I go to a dinner party and say, hey, let's talk about structural racism, I don't go, oh, hoorah, he's a jolly good fellow. I mean, that's not what I'm going to get. I mean, people are going to close down. They don't want to do it. And in fact, even if they want to do it, they don't necessarily know how to do it. So we'll ask Tina Turner to help us in the following sense. We'll begin this conversation relatively nice and easy, the way Tina Turner begins Proud Mary. And if you don't know that rendition, go listen to it after. It's a really good one. So to start nice and easy, we need to move from this particular place to a domain that I call Green Valley Farm. So this is not Old MacDonald's farm, to be sure, but on this farm, there are some horses, E-I-E-I-A. So the conceit is that the horses are sick. And if we had time, we would go back and forth and have a conversation about this. Why are the horses sick, etc.? If past is prologue with respect to that particular engagement and response, I would get two kinds of responses. One set of responses tends to focus on the horses. The horses are sick because they're not drinking enough water, not eating enough hay. The horses are not pulling themselves up by their bootstraps, let's say. It's a story about the horses. Another set of responses focus on the farmer. The horses are sick because of something the farmer is doing to or failing to do for the horses. We might even say that the farmer is a horsist, analogous to a sexist or racist. You get the basic idea. But if we pull back the frame, we begin to see that the horses exist in a toxic environment, which is to say it is a threat in the air. So quite apart from what the farmer is doing to or failing to do for the horses, they're going to be sick. Quite apart from what the horses are doing to themselves or failing to do for themselves, they're going to be sick. Now, our interventions might be, well, let's have them wear a mask. We're in a context in which, I don't want to politicize the conversation, but we could do that as a particular kind of move. Another move we might make is to say, well, look, let's have the farmer listen to the horses, articulate their stories of their marginality. Maybe EDI vis-a-vis horses is okay, I don't know. We could do that. I don't mean to poo-poo either of those interventions. I really don't. What I mean to say is that there's another more structural move that we can make, which is to say, to clean up the environment. And if we engaged in that effort, I doubt that anyone would say, or very few people would say, that's an animal preference for horses. That's just not what we would say, presumably. We would say it's a necessary countermeasure that we're mobilizing to remove the threat so that the atmosphere looks like this. And if it looks like this, it's not just good for the horses, it's good for everyone, right? So that's the nice and easy. It requires us to transcend two frames, a frame about the individual conduct of the individual farmer, and a frame that doesn't focus on the deficiency of the horse. The question now becomes, well, is there another heuristic that we might think about that helps us draw this nexus I'm trying to draw between the then of slavery and the now of the contemporary moment? I want to suggest that there is, And to unpack that particular claim, I want to turn to Martin Luther King and his I Have a Dream speech. So you're all familiar with this speech, presumably, particularly part one. It's a speech that stands in the register of interracial harmony, brotherhood and community, justice and freedom, and where people are judged by the content of their character and not the color of their skin, part one. There's a part two of this speech with which we might be less familiar that is equally important, it seems to me, and that helps us forge that nexus that I'm trying to draw. We have come to our nation's capital to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every America was to fall heir. America has defaulted on this promissory note insofar as our citizens of color are concerned. America has given black people a bad check, a check that has come back marked insufficient funds, right? So what King has in mind is this. Again, students, this is a legal instrument. It's not a cash anything. It's a check. It's useful. It's a check to black people in the amount of civil rights, and it's for racial inequality. King is suggesting that it comes back marks insufficient funds. To use a more colloquial term, the check is bounced. I want to say that's a powerful metaphor, but I want to switch it up. I want to assume that the check has cleared. The point I want to make is that the civil rights check has never been enough to attend to the racial inequality problem to which that check has been applied. And in order for me to unpack that claim, I need to do some structural racism math. No one comes to law school to do math. Stay with me. We can do this math. We don't have to defy gravity to do it. And if you get a little bit lost, just click your heels. You'll find your way back home. All right, so racial inequality 1. That's our starting point. And then when you think about, well, what happens when we subtract a civil rights intervention? And there are two possibilities vis-a-vis the answer. But before we think about those two possibilities, let's make this slightly more concrete. Slavery is racial inequality 1. Everyone agrees that it happens. Almost. And then there's Reconstruction. It's a significant moment in American history, the 13th, 14th, the 15th Amendment. When you do that math, what do you get? When you subtract civil rights intervention from racial inequality, do you get 0 or do you get remainder racial inequality? This is not a rhetorical question. I want an answer. So imagine this is your bar question. So after 3, is it A or B? Okay, I need the Harvard for A or B? B. I mean, so it's pretty uncontroversial. Again, it's pretty hard to do this math and tell me that you get 0. We can dispute what that value is. Fair enough. But you can't tell me that it's 0. So let's carry on one more time. So we have to bring over this remainder racial inequality because we said it wasn't 0. And then we've got to add to it racial inequality 2. And then once again, we have a civil rights intervention. We can particularize this so that we're talking about Jim Crow as the inequality 2, and the civil rights intervention is Brown. And once again, we can do the math. Once again, I'll presume to say that you cannot tell me it's 0. You can have a fight with me about what value to attach to it, but it's not 0. This is important because it suggests a problem of racial accumulation. This is precisely what we mean when we think about structural racism. The structural racism math doesn't equal 0, and it doesn't equal 0 in part because the check is never enough to clear the ground to 0, and because there's a piling on, there's a new form of inequality that enters the scene. It's precisely this accumulation that one might speak loosely of vis-a-vis the afterlife of. In other words, racial accumulation might be invoked to explain extant racial disparities. Racial disparities don't come from nowhere. They're precisely a function of this particular phenomenon that I'm describing. So now we might go back to Tina Turner and ask, so what's law got to do with it? What's law but a second-hand? No, what's law got to do with it? So let's turn to law and legal doctrine specifically. And I'm focusing first, as I said, on the equal protection clause. And the basic question I mean to pursue here is really this. What does equal protection of the law do against the backdrop of these extant racial inequalities? What does equal protection of the law do vis-a-vis the problem of racial accumulation? If we think about racial disparities as a threat in the air, then it takes us back to an intervention we said might be productive. We want to clean things up. That's what we want to do, so that the atmosphere looks like this. So suppose we try to do that. Suppose we said, okay, we're going to clean up racial disparities as a normative project, as a civil rights project. What does equal protection of the law say about doing that? It erects a number of doctrinal obstacles. The Supreme Court has built a wall, brick by brick, that gets in the way of doing precisely what we said would be a way to kind of effectuate a structural move in the domain of race. I'm not going to talk about each of these, but look, think about the intent standard for a minute. If the paradigmatic way is in which we think about inequality in the domain of equal protection is through an intent paradigm, clearly we're not going to deal with racial disparities. If we've taken the view that societal discrimination is an amorphous concept, clearly we're not in a juridical position to deal with racial disparities. If we have as a starting point the idea that any form of racial remediation is suspect and a form of reverse discrimination or racial preference, clearly we're not in the space in which we can deal with racial disparities. I could go on. The point is that equal protection doctrine serves as an inequality-preserving juridical regime. It gets in the way of precisely the problem of addressing racial accumulation along the lines that I've addressed. So let's shift gears to another doctrinal arena. Perhaps the story here will be better vis-a-vis the problem of structural racism. Spoiler alert, it is not. So the basic question Fourth Amendment law asks is, what are the constitutional constraints placed on police investigatory practices? The Fourth Amendment takes up that question by focusing our attention on searches and seizures. We have a right to be free from searches and seizures, unreasonable searches and seizures, I should say more carefully. So what that means is that Fourth Amendment doctrine is structured around two broad doctrinal inquiries. One, is there a search or seizure to begin with? If there's no search or seizure, then the Fourth Amendment has nothing to say about it, which is to say, governmental conduct that is neither a search or a seizure is governmental conduct that resides beyond the regulatory reach of the Fourth Amendment. So a huge question in Fourth Amendment law then is whether this or that action on the part of a police officer counts as a search or seizure to begin with. Move one. Move two, assuming that what you have is a search or seizure, that doesn't mean the government is in trouble. The Fourth Amendment doesn't prohibit searches and seizures writ large, only unreasonable ones. So the second big question is, stipulating that there's a search or seizure, is that search or seizure reasonable? So in the book that Guy Charles mentioned, I try to tell a story about the way in which the Supreme Court adjudicates both of those questions, exposes Black people to a range of violent police practices. I'm not going to unpack all of that argument here quite clearly. I'm just going to ask you to buy the book. What I want to focus on instead is just the seizure doctrine, That is to say, the question of what counts as a seizure in Fourth Amendment law. And the specific doctrinal test for a seizure is this one: whether a reasonable person feels free to leave or otherwise terminate the encounter. So students in the room, how many of you have taken criminal procedure? Oh, not a bad showing. The rest of you, get in that class. So let's think about how the court applies this vis-a-vis Black experiences with policing. And the reason I'm framing it in that way is precisely because almost all the cases that adjudicate the question of what counts as a seizure in the domain of Fourth Amendment jurisprudence are cases involving Black litigants. So I want to think then about this doctrine through the prism of the Black body to get a sense as to what this might mean on the ground. So here are some examples of what the court views as non-seizures in that particular juridical space. That is, police interactions that do not trigger the Fourth Amendment and therefore do not require any justification. So the police may follow people, the police may chase people, the police may question people. Where are you going? What have you been? What are you doing? None of that triggers the Fourth Amendment. May I see your ID doesn't trigger the Fourth Amendment. This analysis does not change if the questioning occurs in the cramped space of a bus, in securitized places like airports, or in places of economic necessity like, for example, the workplace. Let's assume now that in addition to posing those questions, the officer said, well, may I search you? May I search your bag? Are we now in a domain where the person is not free to leave? No, says the Supreme Court. This is still a moment in which the person supposedly is free to leave. I could go on, but I won't. The point I want to make about the seizure doctrine is that it is a doctrinal domain in which captivity is translated into freedom, and coercion is translated into consent. Significantly, when the court says that a particular moment is not a seizure, it is saying that moment is a consensual one. The court has been explicit and emphatic on that particular point. The discursive choice of quote-unquote consensual and quote-unquote free to leave suggests that Black people are consenting to the very forms of policing that leaves them feeling violated, the very forms of policing about which we complain. In that regard, one might say that a particular legal fiction underwrites Fourth Amendment law, to wit, that Black people have the freedom to leave police encounters. It's up to them to exercise that particular choice. This legal fiction, it seems to me, becomes even more problematic when one thinks about how the seizure doctrine, as I've just described it, interacts with the notion of a high crime area in Fourth Amendment law. You may be asking, you should be asking, what is a high crime area? It is an unspecified term in Fourth Amendment jurisprudence that typically marks Black and brown communities. The point is that if a person tries to leave, exercise their freedom to leave, and they're in a so-called high crime area, and they do so by running away, the government is in a good position to argue your unprovoked flight from a high crime area gives us reasonable suspicion to formally detain you, which is to say, even though you're ostensibly free to leave, that's the idea, doing so by running away in a quote-unquote high crime area is a criminal act, the act of, well, running away. Part of what's troubling about the court's analysis is the default that Black people's efforts to avoid the police is unprovoked. The court could easily have mobilized a historical relationship between the police and Black communities, between the police and Black people, to explain why many Black people might perceive or experience policing as a provocation. Instead, the court treats Black people's attempts to avoid the police as a fugitive act, the act of stealing oneself away from the police. Given the work, the doctrinal work that high crime area performs in Fourth Amendment law, transforming Black people's efforts to avoid the police as a fugitive act, we ought to say just a little bit more about how this term works. Drawing on the work of Denise Herbert, we might begin by noting, in some ways, the idea of a high crime area is something of a misnomer in as much as areas don't commit crime, people do. What that might mean then is that high crime area is just another rhetorical register in which to talk about quote unquote high crime people. And think about how that takes us right back to social meaning attributions of race. And indeed, the Supreme Court's application of this high crime area doctrinally constructs not just spaces and places, but peoples and bodies, juridically writing crime into Blackness and anti-Blackness into law. The strong version of this argument would be that Black people's capacity to leave police encounters is an ontological impossibility. A weaker version of the argument is that Black people's right to leave police encounters, when one takes into account the free to leave test and high crime area, puts them in a lose-lose-lose existential position in the following stance. If you remain in the police encounter, in the sense of exercising your freedom to stay, staying in place, holding your ground, asserting rights, is to assume the risk that your life doesn't matter. Against the backdrop of the presumed dangerousness of the Black body, assertions of rights is simply not a safe thing to do. If instead you walk away, you know that the officer can follow you because you know that that's not a seizure. Don't get that wrong on the bar. They may question you as they do so. And if, in a last-ditch effort to signal that you really, really, one more time, really want to leave, run, the government can take an adverse inference from that fact and, as I said before, formally detain you. The short of what I'm saying is that a careful reading of the seizure doctrine through the prism of the black body reveals that Fourth Amendment law constructs black people as free to effectuate, indeed constitutionalize, a particular kind of unfreedom, which is to say, under the racial logic of the seizure doctrine, black people are free to leave the very police encounters in which they are unfree. Which brings us back to this particular formulation. Do we see an engagement of racial disparities? No. Do we see an engagement of social meaning attributions of race? No. What we see instead is a silencing of both notions of race and conceptions of structural racism. Which brings me to my conclusion, and specifically Saidiya Hartman's quote. I'm not going to read that quote. Presumably you can all as I wrap up. The point is that understanding the social construction of race and its linkage to racial inequality, understanding structural racism as a phenomenon that requires neither intentional bad actors nor intentional acts of discrimination, understanding that law plays a constitutive role vis-a-vis racial equality and not just a reflective role, is an important point of entry into precisely what Saidiya Hartman invites us to think about, which is to say that the relationship between slavery and the present is open and unfinished. Thank you very much. Yes.
That was both enlightening and incredibly entertaining. I guess I have a somewhat pedantic question, unfortunately, which is related to early on in the argument, the use of what I would describe as sort of implicit bias type research to get us to the social construction of race. I guess I'm completely on board with the conclusion, but somewhat not skeptical, but curious about how important the reliance on the implicit bias framework is and whether you're willing to kind of give it aside, in part because it also makes me more skeptical of the debiasing techniques, what we know about debiasing implicit bias. So in some ways, it foreshadows a much darker story in terms of the future. So to say a little bit about that piece of the argument.
Yeah, so thank you. So I would say that the implicit bias research is helpful for articulating a particular piece of the social construction of race, but I wouldn't rely on it entirely. And I would completely disaggregate implicit bias research as a diagnostic tool from efforts to mobilize it as a prescriptive tool. So I am not at all in favor of people who use this literature to kind of debias people. I mean, I just don't think there's an empirical basis for doing that, and I think it's otherwise not practically sensible. So helpful in the sense of signaling what's out there in our collective consciousness, but not particularly useful as a predicate for quote-unquote debiasing techniques. Any other thoughts or questions? Yes?
You, early on in the lecture, quickly seemed to me gloss over what appeared to be a distinction between DEI and structural racism. First, did you imply that there is one? And if there is, can you articulate your descent from, I guess, the DEI version to the structural racism as reflected in the lecture?
So Jerry Kong and I have written a paper which goes back to the first, suggesting that one can think about the implicit bias literature structurally. So I see no necessary opposition between DEI and structural racism. I think part of what's difficult about the current moment is that these terms stand up as though they're self-executing, self-defining, when they're repositories for various kinds of arguments. I do think that you have thin and thick conceptions of DEI and thin conceptions of structural racism. So to my way of thinking, so long as the point of departure for these discussions doesn't turn on the idea that we can fix extant social hierarchies by focusing on individual bad actors. If we're off that space, then we're in the direction of something that we might call structural. How thin or thick we are with respect to that move is going to be contestable. Yes.
So I ran here from my criminal procedure class, so I'm extremely happy. And I know some of my students are in the room. We just read Wardlow and we just read, so we've been discussing the role of race in criminal procedure. I want to ask you a meta question. You focus in on criminal law and the criminal system in your array of many sites of structural racism, and you include poverty and education and health and so many. I'm wondering, just to share, what role or how large do you think and how central do you think the criminal system should loom in our understanding of this phenomenon? Is it one among equals? Does it have a particularly special role as we grapple with structural racism?
So I think it has an outside role if we think of criminalization as a trope outside of the formal criminal system. By that I mean, if we take seriously the idea that black bodies have been criminalized, quite apart from whether any particular body is incarcerated, that trope is at play in domains of civil society more generally, and it helps to explain why people are read in particular ways within the normal workplace. So they're not as capable as, precisely because they're presumed to be. So even though the criminal legal system writ large, on its formal terms, deserves our attention, if we think about the relationship between that and criminalized black bodies, then I think it adds to why that should be and remain a significant site for our engagements. Yeah. Frank?
Devon, in the last two parts of...
My property law professor.
Yes, property law, indeed. When you're talking about the 14th Amendment and the Fourth Amendment,
Yes.
the focus seemed to be on certain doctrinal choices that the courts, and particularly the Supreme Court, or we might say majorities of the Supreme Court from time to time have made. Frequently there have been dissents and disagreements, right, among the courts and the Supreme Court about the necessity or propriety of those particular doctrinal choices. So what I'm trying to think about is how or in what respects we ought to regard the doctrinal choices of majorities of divided courts as part of the afterlife of slavery. Plainly, they're not 100% determined by the fact that our society comes out of the history that in fact it does. So I guess what I'm looking for, what I'd be looking, and I'm not expressing a doubt either that the fact that court majorities make these choices are connected in some deep and important way to the history of this country and the salience in this history of slavery, the need to rationalize and defend it at the time when it was officially a part of our institutions and so forth. But there's still a question in my mind about the kind of causality, if I can use that word, you have in mind between the slavery history and what we might think of as the contingency of doctrinal choices made by contemporary courts.
Got it. I'll take one more question, then I'll wrap up. Right behind Frank.
Thank you. I say this, though I love horses, but I'm troubled by the sort of use of a metaphor, or I think you made an allusion to wanting to look beyond the deficiencies of the individual, but there's a challenge there because some people argue that those deficiencies are actually created by prolonged exposure to a flawed institution. So the institution of slavery and its afterlife creating generational harms that are perceptible and measurable and possibly compensable. So I just wanted to hear what we can do about sort of the definite need to kind of pull apart concepts, but also to preserve this idea that there's a strong sort of resurgence of political work around the present legacy of slavery and the lineage of slavery sort of not having been acknowledged or repaired sufficiently. That creates even what we would unfairly categorize as adverse personal choices or things. There's Derek Hamilton of the New School has done some research about scarcity and how scarcity creates the misperception that people who have been exposed to flawed institutions are irrational when they're making the decisions that they can from where they are.
Yes, thank you. Thank you very much for that. And I think I would say language is really important. And I would draw a distinction between deficiency and harm. I think that the notion of deficiency carries with it something about the person, that it inheres in the person. And that's really what I'm quarreling with. Recognizing social harm is precisely the point. I mean, the whole reason I have this stuff on disparities, some people call that deficiencies. I don't view that as deficiencies. There are ways in which people are harmed and experience various forms of inequality that are not about their deficiencies. And I think that's really important to point out, precisely because we live in a context in which, quote unquote, individual agency, et cetera, supposedly explains everything. So that's, I think, the point that I would make there. I don't agree with all of the literature that you refer. I should be clear about that. But I also think it's important to contest ideas that the reason we see this asymmetry is because of deficiencies in people. That I vigorously contest and would definitely stand by that. With respect to the point about majority cause, here's what I would say. I think the pursuit of racial justice in the United States has always had to contend with what I call a racial justice counter-majoritarian difficulty. By that I mean, it's never really a moment in which the nation comes together and hold hands hunky-dory and says, let's fix this. It's typically against an investment in keeping things in place. That is to say, a status quo temporality. So ending of slavery, Brown v. Board of Education, all of these are moments, are counter-majoritarian moments where you get some racial justice win against majoritarian pushing back in the other direction. So if I have that structural frame, then it's easy for me to continue in the vein of the argument that I set out. So thank you all again very much for your time and attention. I appreciate it.